Do you hear me?
Yeah, perfectly clear. So thanks for joining us.
Thanks for inviting me.
You are just after the lunch break, so I'm pretty sure people are energetic here and really to hear all the good things that you're saying, and hopefully lots of questions afterwards.
Sure.
So,
I hope it was a good
right,
lunch,
so
definitely.
I've already introduced you, so take it away, Thomas.
Okay, thanks.
Okay, thanks.
Uh, s- so, as Klaus will then have already mentioned, my name is Thomas Gils and I'm a legal officer at the EU AI office. And today I will be presenting briefly on the AI Act and on some copyright related matters. Just Just a brief disclaimer is that the AI Act is a very vast piece of legislation, and so I will really just briefly give a concise overview of the regulation, and it's definitely not a detailed explanation of all the nitty-gritty details that one can find in the AI Act. A brief word on the AI Office. The AI Office is the key regulatory and coordination player for implementing the AI Act within the EU. And importantly, we will be the sole enforcer of the rules on general purpose AI models. What general purpose AI models are, I will explain later. And so at the EU level, we will be enforcing those rules, but at the member state level, there will be dedicated authorities as well. We have a head of the AI office, Ms. Lucilla Scioli, and I am personally part of the unit A2 titled AI Regulation and Compliance. And so our main role is to further guide the implementation of the AI Act, but also then in a later stage start enforcing it. And we will do so together with our colleagues in the A3 unit. That's the unit called AI Safety, and they will really focus on those largest models and for instance, also monitor the models that pose so-called systemic risks. Other units, for instance, A2, A4, and A5, they are more focused on also fostering research and innovation in trustworthy AI in the EU, while also positioning the EU as a leader in international discussions and a contributor for AI for social good. So that in a nutshell on what the purpose of the AI office is. Now, a general introduction into the AI Act. So as already said, the AI Act is a vast piece of legislation, and its most, let's say, important characteristic is that it is so-called product safety legislation or regulation, meaning that it fits within the broader type of regulation that is addressing product safety and that aims to protect health, safety, and fundamental rights. Moreover, within the EU, product safety legislation is characterized by the fact that standards, technical standards, play a very important role, and that enforcement-wise, market surveillance authorities play a predominant role. And so that differs a bit from, for instance, data protection regulation or consumer protection, where other authorities or play a role, or where, for instance, standards are not really important. Another key characteristic of the AI Act is that it's a horizontal piece of regulation, so it applies across sectors, and it does not necessarily really depend on where AI systems are deployed in a specific sector. However, as you will see, for instance, for so-called high-risk AI systems, there you see still a kind of footprint of currently existing sectoral legislation that keep on being relevant for certain types of high-risk AI systems. And that immediately then also brings me to this third characteristic, the risk-based approach. As I will explain in a few slides, the AI Act uses this risk-based approach where requirements depend on the risk categorization of AI systems. And so the higher you are up on that or in that pyramid, the more rules will apply or the system can even be prohibited. Then more generally speaking, the last two horizontal characteristics of the AI Act is first that the AI Act really addresses the whole value chain and life cycle of AI systems. So it addresses the providers, but also the deployers, so the professional end users, and everyone in between, be it distributors, importers, or other commercial actors. Very important to keep in mind because also obligation-wise, it means that the AI Act sets out mutual obligations between all these actors. And then finally, the AI Act also intends to foster responsible innovation. And it does so by, for instance, excluding scientific research and development of AI system or where AI systems are used, which is very relevant in the context of a university. And it does also do so by, for instance, conceiving so-called AI regulatory sandboxes, which is a mechanism which can be set up by member states to foster trustworthy AI development in a regulated environment, which is kind of a new thing, really. But unfortunately, I will not really address that today, taking mindful of time. So as said, the AI Act uses this risk-based approach. And for someone who may have already had an explanation of the AI Act, this pyramid will then be rather familiar. And this risk-based approach puts AI systems in various risk tiers, let's say. And so the highest tier are AI systems which we deem to pose unacceptable risks to society, to fundamental rights, to the protection of health, and they are prohibited. For instance, certain types of social scoring are prohibited, or the use of certain types of biometrics system for biometrics categorization or emotion recognition. I will further illustrate that on the next slide. Then one step below are the so-called high-risk AI systems. And two brief examples of that is either AI in employment used for specific purposes or AI integrated into medical devices. Then one step below are AI systems that are deemed to pose only certain limited risks, and where we say that, look, in that case, additional transparency should be warranted. And for instance, it should be disclosed when a deepfake is a deepfake or is, in other words, AI generated or manipulated, or for instance, when natural persons directly interact with chatbots, then the chatbot has to make clear that it's not a human, but an artificially powered system. And then finally, there is, let's say, the rest, AI systems that do not fall in one of those first three risk tiers. They are without specific rules applicable to the systems, but the providers and deployers of those systems may still have to comply with the so-called obligation on AI literacy. So they have to ensure that staff is literate about the capabilities, the limitations, and so on of AI systems. And then finally, below, there is then that set of rules applicable to general purpose AI models, and that really address only the providers of those models. Models and systems are separated by the fact that model is, let's say, a component of a system, and where a system is a broader set, is a broader tool, which also encompasses other software, a user interface, and so on, while a model is, let's say, more the mathematical engine of an AI system. Why do we use this risk-based approach? That is to enable AI development in order when, for instance, by respecting standards when conceiving these high-risk AI requirements, and also to foster the uptake of AI systems by imposing certain rules. We hope to increase societal trust in these AI systems. And that is also why the AI Act only addresses the major risks that AI systems can pose, and we try to avoid over-regulating this still nascent sector. From the outset, we aimed at complementing existing EU laws such as GDPR, so data protection, or consumer protection, and other pieces of law. And we also try to keep this legislation future-proof, and that, for instance, is reflected in the use of those standards, as standards are industry-driven and really take into account the technological state of the art, but also codes of practice, which I will explain a bit later, and then potential delegated acts. So let's then move to that first step in the risk pyramid, which are the prohibited AI systems. And in the AI Act, this is a whole article that lists all the types of AI systems that are prohibited, and it would probably take me already an hour to address in detail all those different systems. But I'll highlight two of them on the next slide. But should you really be interested in further understanding this, do know that we published guidelines on these prohibitions back in February. And in those guidelines, you can really find further concrete illustration of systems that then could be prohibited under one of those prohibitions. And so those guidelines really help relevant actors to comply with these prohibitions. But let me just highlight two of them. The first one are these so-called AI-enabled harmful or subliminal and manipulative or deceptive techniques. This is further illustrated by, for instance, the example of an AI companion, a chatbot, that is designed to use emotional cues of its users to further implement to influence the feelings of that user, and for instance, that run the risk then to also make them emotionally dependent on such a companion, potentially also undermining their free choice and incentivizing significantly harmful behavior. That's harmful behavior is really important because that is a criterion in the prohibition. And so such an illustration would be prohibited under the current rules. And then the second one, which is again relevant in the context of a university or at the workplace, is that emotion recognition is prohibited when it is used and when it uses AI. Unless there would be certain medical or safety reasons. So suppose that an employer would use webcams or voice recognition system to track employees' emotions, such as anger. Well, that type of practice is now prohibited and can no longer happen in the EU. Maybe in that regard, indeed, a quick note for the ones that have more legal background. The AI Act is a regulation, and so it does not need to be transposed into, for instance, Danish law, right? A regulation applies directly, and member states do not have to take further transposition measures, except if a regulation would explicitly say so. Then we move to the second tier of the AI risk pyramid, so the high-risk systems. And so when is an AI system in a high risk? That can be in two situations. Either the AI system is embedded into a product that already falls under existing sectoral legislation, or it is such a product itself. And so this existing sectoral product legislation is explicitly listed in the AI Act. I will again not completely go through this list, but what you can think about in this case is, for instance, when AI would be integrated into toys, that is a high risk. When AI is integrated into machine equipment, that would be considered high risk, or radio equipment. And for instance, that notion of radio equipment is a really broad notion. And so already this first type of high risk AI systems is rather broad. However, it depends on existing sectoral legislation and, for instance, the definitions used therein. So there is also this second type of high-risk systems, and that is when they are used as such, as standalone AI systems in certain sectors for certain purposes. Again, the list is on the slide. For instance, when certain biometrics applications are used in critical infrastructures, migration, or the administration of justice. But let me just highlight two more concrete ones. Again, for instance, when it would be used in employment, when AI systems would be used in employment for instance, assigning tasks or deciding on contract decisions, terminations of contracts, prolongations, and so on. That would be a high risk use. Or for instance, when they are used in education for grading students, for steering their educational program, again, that would be considered high risk. So it's very important to understand that it's not just when AI is used in these sectors, but they also really have to be used for a specific purpose, and only then they will be considered high risk. Now, even if a high-risk system would fall into one of those scenarios or situations, then still there is, let's say, an exception or a way out, because if such an AI system would then, for instance, only be used to perform a narrow procedural task or only perform a preparatory task, then it is still not considered a high-risk system, and so it falls out of this categorization. What we mean with narrow procedural task or preparatory task is still currently being clarified by colleagues of mine that are working on respective guidelines. Now, arguably the high risk regime within the AI Act is the most is the biggest one, right? So the majority of the provisions of the AI Act actually deal with the high risk regime. And these systems, they have to comply with certain mandatory requirements set out by the AI Act, and they have to do so before they enter into the EU market. Those requirements relate to risk management, so identifying risks when an AI system would be placed on the market and already foreseeing mitigating measures. It addressed data governance and data quality, so ensuring that representative training data is used when training and conceiving the AI system. Providers have to ensure sufficient transparency towards professional end users, so deployers, for instance, by providing instructions for use, which the deployers then have to comply with logically. They also have to enable human oversight by, for instance, deployers, so that they're able to intervene in the functioning of an AI system through appropriate means. They have to ensure accuracy, robustness, and cybersecurity, and also have to set up a quality management plan, which is a typical requirement that applies under product safety legislation. Now, if an AI system by the provider is indeed brought in line with all of these requirements, then it has to undergo a so-called conformity assessment. And what type of conformity assessment is relevant depends on the type of high-risk AI system. So I will not spend too much time on that because that gets really technical and detailed. But what is important to understand here is that it's really the provider, so let's say the developer of an AI system, that is the end responsible for. The provider is the responsible one for assuring that there is an EU declaration of conformity and affixing the CE marking to such a system. As I already briefly mentioned, these requirements are being standardized and they will or should be turned into harmonized standards, which then can be used by providers to facilitate compliance. Important note in that regard is that these requirements are mandatory, right? So providers have to implement them into their systems, while these standards are voluntary. So providers can choose to follow them, and if they do so, they get a presumption of conformity, so it facilitates compliance for them. A brief note then on the mutual obligations between both providers and deployers. As said, providers bear the main responsibility to ensure compliance with the high-risk requirements, while the deployers, they need to ensure that they correctly deploy an AI system, that they ensure sufficient human oversight, and that also includes, for instance, ensuring that staff that uses these high-risk AI systems are sufficiently trained and that they're sufficiently competent. Logically, they have to use representative input data when using an AI system, when deploying an AI system, and they also have to monitor the working of the system and report incidents, for instance, back to the provider, who can then take further mitigating measures.
Thomas, I'm just interrupting you for a second because I don't know if there's a gray bar and it's covering the headlines of your slides, which is a pity. So I don't know if something that could be changed at your side. Because we see the rest of your slides perfectly, but
yeah, it's the bar of Zoom.
So
Voila. Maybe if I put it here, is that better? Maybe.
So yeah, well now it's at the bottom, but right now it's better. Yeah.
Okay, because now it also disappeared for me. So let's hope that it stays there.
Okay, it looks okay now. So let's go on. Thanks.
Great. So then further word on the obligation of the providers. What they also have to do is to monitor when the AI system has been marketed, so post-market monitoring, and ensure serious incident reporting to the authorities, right? So we already see that there is a kind of chain here where deployers have to report certain incidents to providers, and providers then also have to report back to authorities. High-risk AI system providers also have to register their systems in an EU database, which is obviously important because in that way, authorities can keep track of which high-risk AI systems are actually available on the EU market. And then certain deployers also have to do so, but they have to register that they are using a high-risk AI system, and that is only when public authorities do so. So that is an important limitation in that regard. In addition, again, also certain deployers may have to perform a so-called fundamental rights impact assessment when they are using certain type 2 high-risk AI systems in order to map the impact on fundamental rights and ensure, again, that they take related mitigation measures. That's for high-risk AI systems. Then we move to the third step in the in the risk pyramid. And now we arrive at those systems where we say that that additional transparency is warranted and that specific disclosure obligations should apply. And so the first type of systems that are covered by Article 50 are the so-called directly interactive systems. And in that case, the provider of such a system needs to inform natural persons that are interacting with such a system that the system is an AI powered system, unless it would be obvious to a well-informed, reasonable, circumspect person. Examples of this are, for instance, when interacting with a chatbot or an agent, but it could also apply, for instance, to interactions with Spot, the robot dog, as developed by Boston Dynamics. First type of system. The second type of systems are AI systems that generate or manipulate synthetic content, including audio, video, image, and text. And in that case, the provider of such a system has to mark the output of that system in a machine-readable manner, and also has to ensure that these marks are detectable. This is the moving image that is circulating on the slide, where, let's say, one part of the image is watermarked and the other part isn't. As you can already maybe see, although I can imagine that it's rather small for you in the room, you don't see, as a human, you don't see the difference. So it's not perceptible to us, these marks, but they are machine readable. So dedicated solutions can actually identify and detect those marks. Two important exceptions to this, which are probably rather interesting in the context of translators. It's either when such a synthetic content generating system performs an assistive function for standard editing, then such transparency does not need to be given, or when the system is used to insubstantially alter the input data or the semantics thereof. So the second exception is typically illustrated by, for instance, referring to AI-powered translation tools or tools that, for instance, improve the formulation or the structure of a sentence. That could be used, potentially those systems could fall under this exception, and that is probably rather relevant for an audience such as yours to understand whether or not you can start looking for these marks, or that may not be the case. Then we move to the third type of AI systems that should be complemented with additional transparency, namely the biometric categorization and emotion recognition systems. I will not further explain what that means in legal technical terms, but suppose that these systems are used and are that natural persons are exposed to such systems, then they logically have to be informed about such exposure and about the operation of the system. What has changed for these obligations as compared to the first two I explained is that now it's on deployers. So where the first two obligations were on the providers of the system, so the ones that develop the system, this is an obligation that is on the user of such a system using it for professional, non-private purposes. So that is the first obligation for deployers. Secondly, suppose that the deployer would use an AI system to generate or manipulate a deep fake, then the artificial nature of that image or piece of audio or video needs to be disclosed. How do we define deepfakes in the AI Act? Well, that is any type of AI, video, audio, or image. I see that I made a slight mistake here on the slide, that resembles existing persons, object, places, entities, or events, and falsely appears to a human to be authentic or truthful. So allegedly, this is quite a broad deepfake. And this is also why I included the deepfake image of Michael Jackson here, which went viral, I think, last week due to the release of Sora 2, so a new app by OpenAI, which allows you to really generate these super realistic deepfakes of and famous people, but also less famous people. Interestingly, what you see already here on the slide, maybe you see the arrow, is that they actually include here some kind of watermark to provide transparency on the fact that this has been generated by Sora, so it is AI generated. So this is already an interesting emerging practice and that we see by an AI provider in this case, because the deployer would then be the one that actually used Sora to create this video. In this case, there is not really an exception, but rather an attenuation of the disclosure obligation, because if the deepfake is used or features in an evidently creative, satirical, or fictional work, then the transparency only has to be given in an appropriate manner that does not hamper the enjoyment or display of the work. So in practice, this could, for instance, be used for musicians that would use AI to generate songs, or visual artists that use AI to generate artworks that could feature deepfakes. Then they have this attenuated obligations to fulfill. And then finally, there is also let's say, the deepfake version of text. So text that would be published and that is intended to inform the public on matters of public interest. If that was generated or manipulated through the use of AI systems, then again, such transparency needs to be given. However, an important exception applies in this regard, that such transparency does not need to be given if the text underwent human or editorial review and someone assumes editorial responsibility. So this, for instance, could apply to newspapers that do use AI, or where journalists use AI, but where editorial responsibility still sits with the editor of the newspaper. They probably can rely on such an exception. And then finally, you see the police officer at the left bottom of the left corner of the slide, and that is because to all these transparency obligations, there is an exception to the benefit of certain law enforcement activities, such as prevention of criminal offenses or prosecution of criminal offenses. And so they do not necessarily have to comply with these transparency obligations. But again, I will not further explain that, but still thought it important to mention. Then we arrive at that set of rules that applies to those very large general purpose AI models. And it's important to understand here that in this case, we really only address the models, for instance, such as a GPT model or a Gemini model that then could be further integrated into a general purpose AI system. Think about ChatGPT. So ChatGPT is a system, but it runs on a GPT model. And these rules only apply really to those models and to the providers of such models. And first, we have a set of transparency rules that apply to all general purpose AI models. And for instance, they have to provide certain technical documentation and information both to downstream providers, so other providers that use the model into a downstream AI system, or they have to provide such documentation to relevant supervisory authorities, such as the AI office. That's the first transparency obligation. And second, they also have to set up a policy to comply with EU copyright law, and relatedly, they have to publish a summary of the training data used, and I will explain a bit more on that in the following slides. Then next to those transparency rules, we also have risk management rules, but those only apply to models that pose systemic risks. Now, a model poses systemic risk either when the training used for such a model goes above a certain compute threshold, again, something really technical, or when it has certain high impact capabilities. In the meantime, we published guidelines on this part of the AI Act. So should you wish further to better understand what high impact capabilities mean, again, I refer to those guidelines. What they have to do, so models for systemic risk, they have to do additional systemic risk assessments and perform mitigating measures. or they have to do adversarial testing and model evaluation. They have to monitor incidents and have to take certain cybersecurity measures. I hope you're not being disturbed by the noise here outside, because I think that works are ongoing on the street. So I apologize for that if that is too loud, unfortunately. Let me then move to the copyright-related aspects of the code of practice. Because as I briefly mentioned, so that the rules applicable to general purpose models are divided in, let's say, three sets. So we have transparency, copyright, safety, and security. And then we developed a code of practice together with stakeholders. So for instance, providers of these models that they can use to demonstrate compliance with the rules. One of those chapters of that code of practice really relates to copyright. And that was published on the 10th of July and addresses this one particular article. And this was further complemented with a template that the Commission developed, and that foresees a template for the summary of training content that GPI model providers need to publish. A brief word on the copyright chapter. What this chapter offers providers of these general purpose AI models is a set of practical solutions to meet that requirement in the AI Act to set up a policy to comply with EU copyright law. And so in that chapter, they commit to 5 commitments. The first one is, to put in place and keep up to date a copyright policy. And as part of that policy, they commit to 4 concrete measures, namely, first, to exclude recognized piracy websites from web crawling when they are looking for training data. And so these piracy websites really have to be recognized as such by relevant authorities within the EU. Secondly, they have to respect the state-of-the-art opt-out protocols from the so-called text and data mining exception. This is an exception under copyright law in the EU, which I will try to address at the end of the presentation. And so for expressing such opt-outs, either robots text is typically used or other protocols. But what those other protocols can be, we are still further clarifying that in a process that will be launched in the coming days or weeks, really, and where, again, we will really rely on stakeholder input to identify such protocols and generally agree on them. And a third concrete measure is that they need to take measures to mitigate the risk of copyright infringing output. So suppose that a model is capable of reproducing content that is still under copyright protection. Well, in that case, they really have to ensure that that risk is mitigated or even prevented. And then finally, they need to put in place a complaint handling mechanism to facilitate rights holders to enforce their rights, especially with regard to copyrights or related rights. Now, importantly, these measures, or at least the compliance with these measures by a provider, does not as such equate to complying with union copyright law. And so, for instance, in that regard, the AI office will also only enforce the code of practice and the underlying rules of the AI Act, but will not enforce copyright as such, for which rights holders will need to go to court in the relevant jurisdiction. And secondly, there is this summary of training content that needs to be published. And this requirement applies to all general purpose AI models, including free and open source models. From other rules, those free and open source models are exempted. In addition, they have to mandatorily use the template that was published by the AI office at the end of July. And so they cannot use another template, while, for instance, for the measures under the code, they can actually use alternatives in the case that they wouldn't have signed the code. What is the purpose of this template? Well, it is to increase transparency and facilitate parties with legitimate interests to exercise their rights. Again, predominantly think of copyright right holders or related rights holders to really try to enforce their rights. However, the AI Act explicitly mandated the AI office to take due account of trade secrets of the providers of such models, and that is why the template offers a granular level of information depending on the type of data source. So depending on the type of data source, more or less detail has to be given. And in that respect, we also have the excerpt of the AI Act that explicitly mentions that the summary needs to be generally comprehensive but not technically detailed. And that is also why the summary is not a work per work description of the training data, but rather addresses the data sources in a narrative form. It allows providers to provide general descriptions, and then depending on the data source, they need to provide additional details or not. For instance, when it is about data scraped online by or on behalf of the provider, they need to make a list of the most important domain names that were used, 10% of them, or in the case of an SME, 5%. Or for instance, when this is about large publicly available databases, then they really need to provide the identifier of the database and a link so that rights holders really understand which specific large publicly available database was used. However, if it concerns a private database which was licensed with the rights holder or with a third party, then not much details need to be given because in this case, well, it was licensed, so the data is legitimately being used. So that is the second element actually of the summary. There is also the first element which concerns general information on the provider, the model and the content modalities that were used for training the model or which are the output of the model. And then the third element of the template summary are the so-called relevant data processing aspects. And in that part of the summary, you can have more information on, for instance, measures taken to respect text and data mining opt-outs, or more information on which measures were taken to remove legal content from the training data, which relates to that measure under the code of practice that signatories need to take to exclude piracy websites from their training content. These summaries need to be published on the website of the provider, and they need to be accessible and visible. And they also need to ensure that these summaries follow the model, let's say, through the respective distribution channels. So for instance, on online platforms where these models can be downloaded, then the summary also needs to be available there. So that was a quick, concise overview of the AI Act. And to finish this off, I thought it would be interesting to look at the timeline where we are now. So as I already briefly mentioned, we are currently, let's say, midway something at the timeline of AI Act implementation. Back in February of this year, some provisions already entered into force. Most notably, those prohibitions already started to apply. And so since then, such AI systems are actually it is not allowed anymore to put such systems on the on the EU market. Then at the beginning of August, the rules applicable to general purpose AI models started applying. And in principle, the national governance mechanisms also needed to be in place. However, member states have not yet really, not all member states have yet their national mechanisms in place. So still some work to be done there. Then there is the most important deadline next August, and so in 2026, because then really the big batch of rules applicable to high-risk AI systems, but also to transparency, will start to apply, while also the measures in support of innovation, such as the regulatory sandboxes, will enter into force. Additionally, from that date on, both we as the AI office as well as the national authorities can start enforcing the rules, while now we are currently still a bit in a gray zone. And then in August 2027, then the rules start also to apply to that first type of high-risk AI systems, so AI systems used in toys, machines, or radio equipment. So still quite a bit of work for us at the AI office to further guide and implement the AI Act, but that's a challenging and very interesting task to take. Then to finish off this presentation, I would also still like to address a few topics in relation to AI and copyright, as that is probably also rather interesting to an audience such as yours. And in order to do so, I would like to, let's say, take 3 steps in the AI lifecycle and address a few of related topics in that regard. And so first, let's start with the training of an AI system and the question whether or not or how that can legitimately can legitimately be done in the EU. And so suppose that an AI provider needs to have access to works to train its system, then in order to do so, it will, in principle, first have to ask permission to the author or the rights holder to do so. Now, in the EU, we also have this TDM exception, the text and data mining exception, and that actually can be used by providers instead of a permission. However, the text and data mining exception, we have two of them, and so they only apply in those two cases. First, we have an irrevocable exception that is to the benefit of research organizations, think about universities or cultural heritage institutions. And so they can always perform text and data mining regardless, at least as long as it's for their missions and purposes. And secondly, there is a general text and data mining exception to which all possible actors can rely. However, that is revocable. This can happen through those opt-outs that I already mentioned earlier in the presentation. And so rights holders, authors can opt out from such text and data mining, and they have to do so through certain protocols. This is, for instance, that robots.txt protocol that I mentioned, or other protocols depending on the content modality we're discussing. At the moment, we are still working quite a bit on this together with our colleagues in other than the copyright unit of DG Connect. As we understand that in practice, it's not always really clear the extent to which authors are aware that they can perform such opt-outs or which tools they should use, and vice versa, which protocols the providers need to respect or the extent to which they are aware of them. So we will in the coming months and years still facilitate both rights holders as well as providers to further really progress on this point and to facilitate both parties' interests to really come at a functioning text and data mining exception and the related opt-outs. Then the third possibility to legitimately train an AI system is to use works that are in the public domain, meaning that the author has passed away for more than 70 years in the EU. However, using such public domain data bears the risk that you're using outdated, no longer representative data. And for AI systems, that may not necessarily be the way to go, but it is nonetheless a legitimate way to use data. So that's about the training of an AI system. Suppose then that we move to the two later phases where an AI system is used to create, to generate a certain type of output, and where potentially machine and human co-create, co-interact in order to create certain output. Then a logical question in that regard that has already been asked by numerous authors and by numerous actors in this context is, to what extent can such output actually be protected under copyright law? And in essence, the question that then arises is whether or not there has been original intervention by a human in that process. Originality is an EU notion, so it has been defined by the Court of Justice and requires, for instance, that the author makes individual and creative choices when conceiving the work or making the work, that it bears the personal stamp of the author, and so on. And numerous authors have already made arguments in favor or not of attributing copyright to such works. But the common, let's say, conclusion to that is that as long as there is indeed a sufficient intervention, sufficient creative and original intervention in that whole process by a human, then we shouldn't exclude copyright protection for now. If we take that then one step further, then obviously the question becomes, well, who owns then the copyright in such content that was, for instance, generated by using ChatGPT, Midjourney, or one of the other generative AI tools? And there then the question for now is typically that you really have to go look into the contracts, the terms and conditions that apply to the tool at hand, because typically they will address whether or not these rights are assigned to the user or kept to the provider itself. Importantly also, should there be people in the audience that indeed use a lot of these generative AI tools and are interested to understand whether or not they actually have the rights in such content, it is important to understand that the providers typically make a distinction between the paying models or offer and the non-paying offer, and that can actually have consequence for whether or not rights are assigned to a user, but this is really provider specific. So I can't really make any general conclusions in that regard, but really please feel free to take a look at the relevant terms and conditions that would apply to, for instance, the paying offer that you are using. The final question then in that regard is, well, suppose that output that is generated with an AI system looks really similar to pre-existing human-generated output. Are we then considering copyright infringement? Are we entering into such a situation? And this debate has brought new attention to the debate on whether or not style is protected in the EU, which is why I included the illustration of this image that was generated in the style of Studio Ghibli a few months ago. That was kind of a rage, went a bit viral, where lots of people started generating images in the style of Studio Ghibli, this Japanese animation studio. And then the question arises again, is such a style protected or not? Because under current EU copyright rules, style isn't protected. However, obviously, this really depends on a case-specific assessment, because as soon as it starts to become concrete enough to be identifiable with a concrete work, then, well, that concrete work is definitely protectable. But style as such, as things stand at the moment, is without copyright protection. But maybe in the future we will see political forces that may try to change that debate or position. So this is also another interesting topic to keep aware of. At the same time, maybe also going back to the training of an AI system in the US, there are quite a few lawsuits ongoing on whether or not these providers can rely on the so-called fair use doctrine. And so also the outcome of that will be rather interesting to follow from the EU to see how that could change their offer that they are bringing to the EU market. That was in a nutshell an overview of a few very interesting and copyright topics as well, which brings me to the two final slides to provide you just a brief overview of what we recently did or will be doing in the future. So what we already did is publishing a repository of good practices relating to AI literacy. We published guidelines in relation to the definition of AI system, which is, again, a rather technical notion, and also the guidelines on the prohibitions. With regard to these general purpose AI models, we published, as I mentioned, the code of practice and the template for summary of training data, but we also published related guidelines that further address that notion of general purpose AI models and, for instance, high impact capabilities. Then we have already launched a set of webinars in the context of the AI Pact, where you can find further information on certain specific topics under the AI Act. So I also can highly recommend you trying to look for one of those webinars if you would be interested. And then 2 weeks ago, we launched the AI Service Desk, which is also an interesting initiative because this service desk is accessible to anyone really to ask questions in relation to the AI Act, compliance with the AI Act, or further information. The desk is staffed by highly competent people. So should you have, again, detailed questions on the AI Act, also feel free to reach out to them. Next up is, for instance, the guidelines on the classification of high-risk AI systems. As I already briefly mentioned at the beginning, quite a difficult discussion as well, but we will be providing further clarification on that. The standards for the high-risk requirements should be published, finalized in the coming months or years. Personally, I'm also working on the code of practice on the transparency obligations. So, for instance, those obligations for deepfakes or synthetic content, we will be launching a new code of practices in that regard, which will be then also be complemented with guidelines on the definition of deepfake, for instance. And I am personally working on this, and we just closed stakeholder consultation and a call for expression of interest for participants to this. So this is also something that will really be interesting to follow in the coming weeks, months, and year, really. Tons of other things we are also still doing, but I will leave that for now. I hope my presentation was a bit interesting and that you learned something more about the AI Act and copyright in the EU. So I would like to thank you for your attention, and I would still wish you a very lovely afternoon for the remainder of the day. Thank you.
Let's just see if anyone has questions for Thomas at this point, either here in the room or perhaps something in the chat. I don't know. For the thing. No, okay. And in the room? Yes, we have a question.
How do you expect it to keep up their compliance or check the compliance?
Could you hear this?
Partly. So if you could maybe rephrase the question, that would be useful, I think.
Yeah.
How will you control that people comply with the legislation?
Okay. So how will we control whether people comply with the legislation? That is the question, right?
Yes, that's it.
Okay. So yeah, this is a topic that I didn't cover in great detail in this presentation. So the majority of the enforcement will be done at member state level by these market surveillance authorities. At this moment, there are already market surveillance authorities in all of the member states, but they often still have to be appointed or modified and also ordered to be competent under the AI Act. And so what is important here is that especially for the high risk systems, as they can use standards, they can enjoy this presumption of conformity if they use standards duly. And then it will be for market surveillance authorities to potentially check whether or not certain systems do indeed comply with these standards. This is the system that is already in use, for instance, with toys, right? So suppose that a toy in a certain member state is being controlled, raises certain risks, then these authorities will inform the other member states authorities so that then they also can check for compliance. But now it's really a matter of also ensuring that this is applicable to AI systems. Then for the general purpose AI models, we are competent, so the AI office does that enforcement directly, and we're also competent for enforcing a subset, let's say, of systems that are also provided by the model provider. So this would, this is a very specific type of situation where we also deem that harmonized European enforcement is desirable. So yeah, again, I mean, this is a technical topic as well. I hope that I addressed the question, but this is really something for member states also to duly address enforcement of these rules.